SDSU to the SDSU Retirement Association. I am glad to be joining you this morning. It's nice to see that we have so many people joining us, and I look forward to this being available to people online in the future. Quickly about myself, as far as why is it that I am qualified to opine on these subjects? I'm a trust and estates attorney. I work here in San Diego. It's all I do. So this is my focus. So I do forward-looking planning with people when it comes to establishing documents that are going to, benefit them and kind of guide things as far as healthcare, wills, trusts, and then that's about half of my practice. The other half of my practice is working with people after death or incapacity in order to carry out the wishes of the people who establish these estate plans after they've either passed away or can't act on their own behalf. So I'm going to return for a moment to the beginning of our series. We talked about a number of different things, including what participants wanted to get out of it. And I just wanted to let you know that the slides that we're going to be going over today, as well as the topics, are a direct response to that. So we were able to incorporate those. And then also some of you were kind enough to submit questions in advance. And this is a really well-run program. So the people at SDSU Retirement Association were able to provide those to me, and we're going to be able to answer every one of them, I believe, during our conversation this morning. And then again, before we're done, we're going to make sure to leave about 15 minutes to discuss any additional questions that pop up. So what you're going to see at different points during our conversation this morning is this Venn diagram that's in front of you. I'm going to start scribbling on it at some point, and it's going to get messy, and that's because I'm a messy guy. I like to keep things simple, clear, planning-wise, but what we're going to do here is we're going to mark it up so that I can draw your attention to different aspects. So generally speaking, we put all of this in a single slide in order to point out the fact that an estate plan is more than just a single document when it's executed. And so we're going to return to this, as I said, multiple different times. But during that first conversation, we were able to discuss the fact that you have an estate plan, whether or not you know it. And so, our focus is kind of talking about the difference between default law and proactive planning. And so one of the things I like to do early in this discussion is to kind of bust some myths, meaning that, my goal is to make people feel better, to reduce some of the stress that's associated with this topic. And I think the biggest thing that I like to address just right out of the gates is that the government, the state of California, taxes, whatever it is not going to take your assets from you if you rely on the default plan. Meaning, let's say that you have no proactive documents in place. Let's just say you're carrying along, you decided that you don't want to deal with it, or you revoked everything, whatever it was. The logical consequence of that is not that everything you worked so hard to save during your lifetime, et cetera, is just going to default to the state coffers or something like that, or the federal government's going to come in. And so, I like to share this illustration. So it's a table of consanguinity. And this is what the California default estate plan is if you don't take any proactive steps. So if you were to pass away and you had nothing in place, by and large, everything is going to stay with your spouse or lineal descendants. It's kind of like medieval times or something like that. It stays in the family. It goes down the line. And so as a jumping off point, I I feel like this is good news for a lot of people, right? So again, point is to kind of take the temperature down, so we're less concerned, and it's a matter of, so if you were to pass away, and we're going to talk before we're done about the difference between community property and separate property. But again, the idea is that it's either your spouse who's going to receive your assets, and, or your spouse and your children. If you have no children, it's going to go to your grandchildren. By chance, no grandchildren, great-grandchildren. Let's say you don't have any lineal descendants on this line. Well, then it's going to stay in the family still. And so we pop over here, and it would go to parents if you were, let's say, unmarried and no children, parents, siblings, nieces and nephews. And so it's very orderly, it's logical. So the goal, I've got an itchy nose this morning, excuse me. The laws in California were written by Californians, for Californians, right? Big Brother was not out there, you know, with green eyes, just looking to penalize people who did not take proactive measures to come up with their own estate plan. Now, I like to just point out that, you know, there is an estate tax, right? There is a tax. It does exist. And so, you know, don't hear what I'm not saying. There is a level of assets over which the government is going to levy an estate tax. But thankfully, for most people, it doesn't apply to most people. So what we have here is a table, and it shows, you know, 2001 to 2023, and it's a historical view at what the estate tax exemption amount is, what it has been, and what it is right now. Meaning that if you pass away, let's just jump to 2023. So we're right here. If you pass away in 2023, and your estate at the time of your death is under $12.9 million, you do not have to worry about an estate tax, right? So that means that everything in your estate is going to be able to be transferred, passed to your beneficiaries via a will, a trust, beneficiary designations, whatever it is, without any imposition of a tax related to your death, okay? And that's true at the state level. There's no estate tax in California that the state imposes, and it's true at the federal level. So there's no federal tax that's going to be imposed if you're under that limit. Good news for married people, you get to double that because it's per person. So a married couple could pass away with over $25 million in assets together, and estate tax is not even part of the conversation. Now, there's issues regarding potential capital gains tax in the future. There's still income tax issues, but we're used to that, right? That's part of daily life. So again, in the interest of dispelling myths or making people feel more comfortable, unless you are over that limit, you do not need to worry about it. And let's say that you're in a position where you are over the limit. Let's say it's you have $12.93 million. Only the amount that exceeds your exemption amount is going to actually be subject to the estate tax. So instead of subjecting the entire $12.9 million, if you were to pass away with 12.93, you're over the exemption amount by $10,000. So only that $10,000 is going to be subject to the estate tax. There's some fine print when it comes to this, like everything, you know, lifetime gifts are involved, et cetera. And if you have a narrow question at the end of, or even a broad question at the end of the presentation, we can talk more about it. But so why do we show this in a historical context? Mainly to highlight the fact that this changes, the number changes. Now, it's indexed for inflation, meaning it changes year over year. So that's responsible for part of the change, but it's not just that. This is a political animal, right? It has a lot of meaning, political significance that kind of actually exceeds the financial implications of it. As we look down here, so 0.2% of people who pass away in a given year are actually even subject to the estate tax. So it's a pretty small group, but people like to talk about it. And so what we see here between 2017 and 2018, the exemption amount doubled. Okay, that is not the result of indexing it for inflation. Instead, that was the change of a presidential administration. So the incoming administration associated with President Trump made this a major focus of theirs. They really wanted to increase the exemption amount so more people could pass more funds without being subjected to the estate tax. And so they wanted to eliminate it entirely. There was budget rules that prevented it. But they doubled it, right? So just year over year, we saw this amount double. That's significant. When the current presidential administration came in, there was a lot of conversation about, this president comes from a different ideological perspective. Is the current president, President Biden, is President Biden going to reduce it? Is he going to take it back? And of course, there was lots of conversation about that. Plenty of people organized speculative continuing legal education, and good for them, right? I love that they research it because I don't. But the smart money was saying, okay, if it's going to be reduced, it might get reduced to around $5 million per person. Was that gospel, right? Is that exactly what would happen? No, because nobody knows, right? That was an informed estimate. It was a guess, but ultimately it was a guess. So why do I keep going on about this? Number one, most people don't have to worry about the estate tax. Number two, if it's reduced, most people think that it's still going to be a particularly high level. $5 million per person is a significant amount of money. Furthermore, it's doubled if you're married, so it's $10 million for a married couple. Okay, so that's one part, right, that I want to point out. The final part, though, is just that this changes, right? So you need to pay attention to the news. Frankly, it's going to be big news if there was to be a major change, but we can't know what it's going to be in the future. So that's like, a reason to keep an eye on things. And if there is a major change in the future and you bothered to invest some effort and time in planning, touch base with the attorney who prepared it for you. Ask simply, what are the implications of this change for me? Save your attorney some effort if it changes from 12 million to 10 million or 8 million and you're under that amount. I think you're going to be okay. But if when you think about your total net worth, it's starting to push up on one of those limits, if there was a major decrease, revisit it, right? It's great to be able to put these things in place, but it does require a certain amount of attention. And now I can tell you also, though, as an attorney, again, I'm poking holes in myths, right? My general goal is just to kind of reduce the stress associated with this topic. I can tell you that as an attorney, this is a slow moving area of the law, not tax, right? Taxes actually moves quickly, right? And there's changes every single year, sometimes twice a year. There's court rulings, et cetera, right? But estate planning as a whole in California moves slowly. So I say that in order to point out the fact that, so I administer trusts after somebody passes away, and I have administered trusts in the last year. Some of them had been executed in the 80s and no changes had been made to them. The document functioned, right? The document got the job done. It may be that there was a minor change, right? And we're gonna talk more in a minute about one of the biggest differences that's relevant, that is worth visiting. But on the whole, this is not something that you need to be tuning into CNN or Fox or whatever it is every single night thinking, how will this affect my estate plan? Generally speaking, this is a slow moving area of law. Okay, so let's talk about the components for a minute. Let's talk about the components, and we're going to use our Venn diagram here. So we have some documents that are effective during our lifetime, and then there are others that are only effective after death. What does that mean? Okay. Effective during lifetime means we're focused on incapacity. So incapacity, briefly, you are alive. However, you lack the ability to act on your own behalf as the result of, for example, a coma following a car crash, right? You're alive, but you're incapacitated. You can't write checks. You can't communicate with your healthcare provider. You could become incapacitated or lack capacity as a result of your body outliving your brain. So you may be dealing with memory issues, dementia, Alzheimer's, things like that. And those are incapacity issues. So in that context, we are focused on a power of attorney for asset management and an advanced healthcare directive. If you have a trust in place, there's provisions of your trust that normally kick in. Guardian nominations are relevant only if you have minor children. And then a community property agreement is not relevant in this context per se. So at their most basic level, these documents, let's focus on the, excuse me, let's focus on the power of attorneys. So these documents, while you're healthy, allow you to identify a proxy. So choose an agent, right? So I am nominating this person who she's going to have the authority as defined by the text of this document to act on my behalf. When? What's the triggering item that is going to empower her to start acting on my behalf? It's either going to be effective immediately when you execute the document, or it's going to be effective on your incapacity. So, you know, pardon me. So one part, you're appointing an agent. The second part of the document, you're outlining your preferences and your wishes. So easiest example in an advanced healthcare directive, let's say, you're giving instructions regarding donation of organs, or at what point do I want to continue receiving care versus, you know, when should we discontinue care? So the goal is twofold. One, identify a trusted person, execute a document in a format that's going to be accepted by third parties, okay? Two, you're sharing your preferences after thinking about it while you have capacity, while you're able to do it. And I can tell you these documents are wonderful, okay? They get it done. They're accepted by banks. They're accepted by doctors and hospitals, right? They're accepted by managed care facilities or retirement communities. They work. This is not something that requires a significant legal review by the legal department or something like that. These are well-established, well-known traditional documents that get the job done. So a couple questions came up related to this. One question that was submitted in advance was, where can I access a will? The question was about a will, but where can I access these sorts of estate planning documents for free online? I said when we first met, I'm a big fan of DIY if that's what's going to get you to the finish line, right? If you know I'm insistent on doing things myself, great. Okay, let's get it done. So what you do is just do a regular old Google search, okay? If you're paying attention or taking, I hope you're paying attention. If you're taking notes, right, you can write down California statutory form, okay? California statutory form, and then fill in the word will, okay? California statutory form, power of attorney for asset management, California statutory form, advanced healthcare directive. Now, I'm saying California statutory form. What does that mean? Let's break it down real fast. California law is they promote access to these documents, right? So they've put a sample, usable, wonderful document that is published for free, available to download, and they work great. You got to follow some instructions, but they are meant to be completed and executed by persons who are not attorneys. They're meant to be completed, executed, and used by people who are not being advised by attorneys. So do it, okay? Follow the instructions, read it, but California statutory form, and then you fill in the blank, power of attorney for asset management, advanced healthcare directive will. One thing I'm gonna say real fast regarding the wills, there is a statutory form for the will, and it is confusing, right? The other two are great, right? The healthcare directive is awesome. the power of attorney for asset management, let me qualify that. It's going to take 15 or 20 minutes to read through it and feel comfortable with it. Okay. Regardless, do your best. Okay, because your best is better than nothing. And the law respects intent. So if you're trying to show intent, let's not worry about, you know, somehow there's not a boogeyman out there attempting to penalize you for failing to fully understand the document. They're important. You should understand them, right? But do your due diligence and then carry it through and get it done. The will, though, the statutory form for the will is tough to understand. So what I'm going to point out is that California has something called a holographic will. It is super simple. There's something like 3 or 4 requirements, right? Meaning it needs to be in your own hand, handwritten. You need to make clear that it's your will. It shows your testamentary intent. Okay, so shows intent. It's in your own hand. Do not type it. Okay, it will fail if you type it. Handwritten, shows testamentary intent, and it is dated and signed. That's it, right? So long as you satisfy those requirements, it's a valid document. It'll be respected by a court. You can carry it through. I've done it. I've brought those documents to court, and there's no question, right? It's acknowledged in the law. So when you're doing a Google search, look up instructions for how to make a holographic will in California. And you may realize this is a bit easier than using the statutory form. Okay, I'm going to jam. So that was an answer. That was an answer to one of the questions. Another answer: who do we nominate? Who are our agents? Who's going to act on our behalf? So one of the questions was, does it have to be a relative? Answer: absolutely not. Right? Quick answer, no. I'm going to give you a little more than that, right? But another question that we received was, you know, how do you determine who that person should be? Both are great questions, right? So number one, there's no relation requirement. Number two, it's worth thinking about, right? So the fact that we're asking the question, that we're having this conversation, great work. This is the person who's going to be responsible for a whole slew of everyday activities. Okay, and so we often think about a real clean situation, right? Death, post-death administration. The truth is, this person is going to be acting for you potentially in an incapacity scenario. So you're alive, you're dealing with it, you're living with the consequences of their choices. Choose somebody you trust, choose somebody you feel comfortable with, choose somebody who is you're going to be able to interact with in a setting where you potentially feel compromised or it's extremely private, right? Healthcare related, personal needs, those sorts of things. You love your child, but if that's going to interrupt your dynamic and you don't think that they're going to respect your wishes, they aren't a good person to nominate. So keep thinking through it. Something to pay attention to, consider nominating somebody who's younger than you. They don't have to be your first nominee, but they're a good second nominee. When people are constantly nominating their siblings who are their contemporaries or their elder siblings, when you just think about it, the mechanics, when you need them most, they might need the same thing you do. So consider nominating somebody a generational level lower. What if you are the only one in your family living on the West Coast, or you realize that nominating a family member may not be the best idea, right? And so plenty of people are well served by family members. Otherwise, there's also a ton of reasons to avoid family members. California has a wonderful setup. So it's the Certified Licensed Professional Fiduciary, CLPF, okay? They're professional agents. They're professional trustees, okay? And they do this all day, every day. And the neat thing is they're working for you, and you didn't raise them. And while you may rely on them and they may care for you, you don't love them and they don't love you, which means you can get down to business, and that's really cool. And so there's tons of people who, for one reason or another, don't have anybody that they can rely on. They choose to involve a professional so that they can maintain the status of their existing relationships. They don't want to deal with that strain. A certified licensed professional fiduciary in California, they're vetted by the Secretary of State. They register, they have to show how much they have in funds. It's a great program that's not available in every state. So it's worth looking up, CLPF, and then interview them, talk with them. Make sure that if you need them to act under a healthcare directive, in addition to your trust, will, and power of attorney for asset management, ask them, make sure. But I got to point out, right, these documents above the line are all fiduciary financial. They're little, they're substantively, qualitatively different than your healthcare directive. Your neighbor may be very well suited to be your agent under a healthcare directive because they understand you, they know your preferences, et cetera. Your neighbor may not be well suited to manage your money, make sure bills get paid on time, et cetera. And maybe that's just crossing the line as far as your relationship with them. So knocking down questions asked. One of the questions that was asked was, should we got a question that asked trust or will. Okay, again, this isn't sales, right? I'm not here to get new clients. I'm not trying to convince you to work with an attorney. So wills work in that they allow you to designate who your beneficiaries are in a manner that's totally independent of the California default. Okay, so there's plenty of people who under no circumstances do they want anything going to their villainous brother, right? No way. Okay, that's great. This is just the default if you don't take any steps. If you know that this is terrible, right? Or your child's gonna harm themselves if they get access to that much money or whatever it is, right? Take some steps, right? You're able to do that. We talked about a holographic will. So wills work, okay? They will enable you to choose who gets what. It could be your friend, it could be your neighbor, it could be your romantic partner, it could be an organization, a charitable organization, whatever it is. It could be all of them to a certain degree, right? Each one gets something. Wills work. What wills will not do is enable you to avoid probate, okay? So is a will enough to avoid probate? Absolutely not, never, nope, nope. It's unfortunate, right? So in California, what's probate? So in California, if you rely on a will only to allocate your assets, before that'll happen, before a bank will give $50,000 that you left to your nephew, before they'll give that money to your nephew, a court has to weigh in and say, yes, this is a valid will. Yes, this is the last will that was executed. Yes, there's no creditor who has a superior claim, et cetera, et cetera. The court review process when we're relying on wills only is called probate, and that's the probate administration. Frankly, it works, right? It's the reason that you have secure title to your home, even if somebody died when they were in it and didn't have a will. So again, don't hear what I'm not saying. Probate is not an enemy. It is a useful part of our society that is very, very effective. It's the reason that you can comfortably buy a home that costs, you know, hundreds of thousands of dollars or $1 million and not worry about the chain of title because probate was involved and we had a court weighing in, stamping it, saying, yep, you can make this transfer and nobody's going to come back to you later and say that's mine. But if you can avoid it, there's reasons to avoid it. So why? It's super time consuming. Currently it takes like 6 to 14 months to get through a probate. I filed a petition. We're all done. Figured everything out. Went through the notice period, dealt with any potential creditors, gathered everything into one bank account, and I said, wonderful, let's get this done. We filed a petition for final distribution on Tuesday in my office. We got a hearing date for November 28th, even though we started this process, right, over 6 months before that. It's just a function of the fact that administration's difficult. The courts are weighed down with a bunch of cases. It's a necessary evil, but it's one of those things that you can sidestep simply by having a trust, okay? So so we'll get back to the basic concept in 1 second. And guys, I'm gonna start talking faster because our time together is starting to slip away. But so probate administration, time consuming, public. So all of your your will be published. It'll be part of the court. Your assets will be part of an appraisal and an inventory of assets that's filed with the court, and it's available. I mean, do most people care enough about you to look it up? They don't, but at the same time, right, people are generally private about that sort of information, and you lose that ability when you go through the probate process. Finally, and this is the big one, right? It's the cost, right? So attorneys get paid based on the fair market value of assets. And let's just think about a home for a second. If you die and you want to pass your house using a will, and let's say the house is worth $600,000. Now, like plenty of people in California, it's subject to a mortgage. You only have $250,000. Nope, that's going to be difficult. You only have $200,000 worth of equity, right? So there's $400,000 difference. Well, the attorney's fees are going to be determined based on the fair market value of the home, not the equity you have in it. So in this example, a $600,000 house, in order to transfer it according to the terms of your valid will, it's going to work, right? But an attorney's going to get paid $15,000 to walk it through probate. Okay, and that's because it's based on the value of the assets, and that's $600,000, right? If there's bank accounts that are subject to it, if there's other assets, a car, jewelry, whatever it is, let's say that it got up to $1 million, that's $23,000 in attorney's fees. So that's kind of the no-brainer in California. Who's subject to probate, right? Not everybody is subject to probate. You can use beneficiary designations to transfer. It's called the non-probate transfer. Stakes are kind of high. You need to pay attention if you're doing this, but not everybody's subject to probate. So I use the example of a house. Of course, you could have a joint tenancy with right of survivorship. There's ways to skirt the probate process. You just need to be paying close attention. So assets under $184,000, even if they're held in a bank account in your name as an individual and subject to the terms of a will, you can transfer them without a probate. But you know, that's kind of a more nuanced conversation. So why does that work? Because trusts are kind of like boxes. So the concept is you transfer ownership of those assets into the trust while you're living. It's held inside of that box. You're the trustee, you're the settlor, you're the beneficiary during your lifetime. At some point, you're going to lose capacity or you're going to die. Okay, and then the trust gets handed to your successor trustee, just like your agent, same concept, that you nominated. And that handoff does not involve the court. It's that easy, right? It's like they work. Again, they work relatively well. And they are significantly cheaper, faster, et cetera, than going through the probate process. So that's a clear response to one of the questions that we received. Okay, we're doing pretty well regarding time. Okay, so let's take a quick look pardon me. Notice that these documents, so all of these documents are part of a single estate plan. This isn't like one or the other, right? If you have minor children, you're going to want to execute a guardian nomination, right? If you need to transfer assets, you're going to do a trust and a will, okay? It's not one or the other. Why is that? Because they all work together, right? These things all appear on the same screen and are part of an estate plan as a whole. Now, there's circumstances under which some of the documents may not be necessary, but generally speaking, you should be thinking about how these documents overlap and how they can work together. So why do you have a trust and a will, real briefly? So if the trust is like a box, a will is like an umbrella. And it says everything that can be pulled into the power under a will, which means it's not held in the trust and it's not subject to a valid beneficiary designation. So it scoops up stuff that's floating out there. It's a pour over will. It says gets poured over into the trust, which is good because the trust is where your instructions are. It's where you indicate, you know, who should receive what, how, when, etc. Okay, so let's talk for a minute about, okay, so this is a type of trust. This is in the weeds, right? This is kind of nuanced, but remember when I said trust in the state's area of law moves pretty slowly? The one exception to that, there's plenty of exceptions. The most significant exception these days is the difference between an AB trust and a survivor's trust, okay? And so this is something where if you have a trust, it's worth asking your drafting attorney or taking a look at it. I'm happy to review it briefly to answer this question, et cetera. But what's the big difference? So AB trusts used to be really popular a while ago. And at that point, they were necessary for tax planning. So back here, right, we have under $1 million for an exemption amount, under $700,000, right? So a lot of people were using AB trusts for simple tax planning. And the biggest consequence of it is on the death of the first spouse, it splits into two trusts, okay? This one's irrevocable, this one's revocable. It significantly increases the amount of administrative effort that's required after the first spouse's death, okay? I don't have time to go much more into it than that. In a survivor's trust, on the first spouse's death, this second trust is not automatically created. Now, there's plenty of valid reasons to still use an AB trust. It's just not necessary anymore for tax planning purposes. And so that is something that's worth checking if you already have a trust, right? And that's worth having a brief conversation with somebody about. So for those of you to whom it applies, that's worth taking a look at. Okay, so there was a question that I want to respond to that asked, my parents are 86 and 91, looking for guidance on what should be done now while they're alive. And this is the perfect time to talk about it, right? So I don't know if they both have capacity, but this is the time to review their documents with them, to make sure that they say what your parents want them to say, that the right people are nominated to act and under these different documents, that the right people are nominated to act up here regarding the fiduciary documents, and the right people are nominated to act under the healthcare related documents. Because if they have capacity, you still have time to update it so it reflects their preferences. That's one thing. The other thing is if they have a trust, to make sure that assets are appropriately titled in the trust. Because if they're outside of the trust, this pour over will, let's say, if they have one, is going to get it into the trust. But if we're relying on a will, we are dealing with probate again. And we want to avoid that if at all possible. So checking title to their assets, super, super important. It can be fixed now, which is great. So that's worth doing. And then the other thing that's worth checking on, not just title, but beneficiary designations. And again, your goal is to make sure that it represents their wishes. It's also, I'm talking about legal documents, et cetera. It's also a good time to talk with them, like what are your preferences regarding, your care if you are to lose capacity. I know they're already at an advanced age, but, even asking for input regarding post-death. If you think there's physical objects which are going to cause discord in your family, we use the example of grandma's tea kettle. Ask them to make a decision now and say who gets what. Because if you're worried that your siblings are going to fight over it after they pass away, make them parent. Parents make tough decisions all the time. This is one more thing. And if they leave it and specifically state, or even better yet, transfer it during their lifetime to that person, then the problem doesn't get passed on to the next generation. Additional question that we received was asking about Prop 19, rules for a beneficiary. So Prop 19, for a long time, there was a rule that said that, what are we talking about? We're talking about transferring assets from a parent to a child, or a child to a parent, and maintaining the underlying property tax basis. So think about that house in Allied Gardens. Someone's been living there for 30 years. And when they bought it, wow, so exciting. They paid literally $60,000 for it, or even less or something. Their property tax is based on that initial purchase price plus a limited increase. For a long time, after their death, they could transfer it to a child who could then receive it and continue to maintain that low property tax basis. So instead of paying a property tax based on the fair market value as of the parent's date of death, hundreds of thousands of dollars more, right? They're instead able to maintain the, minuscule property tax payments that their parents have been making since they purchased it. This all changed over 2 years ago or so. It used to be that this was like a great way to receive a piece of property, maintain it as a rental, and you could show positive cash flow because the property tax wasn't getting pulled out, et cetera. There was a specific law, Prop 19, that changed all of it. And so who's eligible now? It has to be, again, parent to child transfer. There's child to parent transfer, which is a separate conversation, but it has to be parent to child. It has to be the parent's primary residence. You used to be able to apply it to $1 million of additional property, and it could be rental property, commercial, whatever it was, right? But it has to be where the parent was living during the last 2 of the 5 years. And then the recipient child has to also use it as their primary residence in order to maintain that low property tax basis, meaning that they can't use it as a rental or else they'll lose the property tax basis, et cetera. So big change, it really narrows it down. Just think primary resident to a child who's also going to use it as a primary residence. That's it. It's really restricted. So I promised to limit my discussion or my part of the presentation to 45 minutes. We're coming up on that. So I'm going to stop now, and hopefully people have some questions that we can respond to. I'm happy to answer questions. If it feels like your question is super, super, super narrow and it's going to require a significant amount of explanation, I'm going to ask you to hold on to it and say we can talk about it later, and you can send me an email or something like that. We're looking for questions that are generally applicable, but of course, ask specific questions that apply to you, but I'm just letting you know in advance if it's too hyper specific, I may just table it.